Hi, welcome to this lecture on the responsibility to protect and prosecute. My name is Lars Waldorf. I'm with the Center for Applied Human Rights and worked for a while in Rwanda for Human Rights Watch a number of years after the genocide. What I want to do today is really cover two topics. Take you through the shift from humanitarian intervention to responsibility to protect, and obviously define those terms and some of the complications that come with it. And then also talk about how the responsibility to protect and the International Criminal Court and international criminal law intersect. There has been increasing talk about the International Criminal Court becoming a tool in the R2P toolbox. So we want to talk about that, particularly as that's something that we have seen both with Darfur and Libya, and there's been at least talk about it in the context of Syria. So let's start with a definition of humanitarian intervention. There are numerous definitions out there. I like this one by Alan Cooperman, partly because it's really quite comprehensive. It makes clear that humanitarian intervention is not just military intervention, but also includes the use of diplomatic and economic resources. And again, what humanitarian intervention is about, or is supposed to be about, is about protecting civilians who are endangered in another state. There are numerous types of humanitarian intervention, and I want to go through and talk about three different ways to categorize humanitarian interventions. The first is whether we're talking about peaceful or military interventions. Again, if we go back to Cooperman's definition, it's clear that diplomatic and more humanitarian interventions are oftentimes peaceful. So you have the UN Charter of 1945, which has different sections. Chapter 6 covers peaceful or pacific measures. Chapter 7 covers military measures. And both Chapter 6 and Chapter 7 relate to the powers of the UN Security Council, which, as you will know, is made up of the P5 or Permanent Five, US, UK, China, Russia, and France, as well as a rotating number of other states. So in terms of Pacific measures, there's things like diplomacy, there are weapons embargoes, there are targeted economic sanctions, and peacekeeping operations. Most peacekeeping operations are Chapter 6, though in recent years, partly as a response to failed peacekeeping operations in places like Rwanda and difficulties in recent peacekeeping operations in the 2000s in the Democratic Republic of Congo, peacekeepers have been given more authority by the UN Security Council to use force, not only for force protection, but also to protect civilians. So oftentimes, peacekeeping operations now tend to be referred to as Chapter 6.5, even though there is really no such thing. They're really typically they lie somewhere between Chapter 6 and Chapter 7. Then the UN Charter Chapter 7 also allows for military measures, and these can include a number of different measures. It doesn't have to be just military forces on the ground. It can be no-fly zones, as you had in Iraq after the first Gulf War, or it could be aerial strikes, as you had in places like Kosovo and in places like Libya, where again the intervening forces in both the Kosovo and Libya cases, NATO, were unwilling to commit troops, ground troops, and relied on aerial strikes instead. So another way to distinguish between humanitarian interventions are those that are consensual versus those that are non-consensual. And really what we're asking there is whether the affected state consents to the humanitarian intervention or not. Obviously, when a state consents, there is a greater respect for that state's sovereignty. And so in the discussions that you see in the news nowadays about various forces, foreign forces attacking ISIS in Iraq and Syria, these are different. In Iraq, there is the consent of the government of Iraq, so there's no problem. That is a consensual intervention. In Syria, on the other hand, the regime of Assad has not consented, and so the attacks on ISIS on Syrian soil are done without the consent of the state. The final sort of way to think about humanitarian interventions is whether they're unilateral or multilateral. And again, unilateral interventions will be a single state intervening on its own. Multilateral is typically done under the auspices of the United Nations or under some sort of regional umbrella group like NATO or ECOWAS for West Africa. Just to be clear, however, the difference between unilateral or multilateral isn't just about whether there's one actor involved. So, for example, with France in Rwanda in Opération Turquoise in 1994, the UN had deputized France to act on its behalf. And so that was a multilateral humanitarian intervention, but only one single actor, France, was conducting that multilateral operation. Okay. So I think it's worth just highlighting that there are a number of key modern cases, which I've listed on this slide, ranging from the Iraq no-fly zones that started right after the first Gulf War up into Syria today. And again, these are just the key cases. There are other cases out there that one could list. For example, Burma, Myanmar, there was consideration of whether there should be humanitarian intervention in the wake of Cyclone Nargis. There is also the war in Sri Lanka that brought up issues around humanitarian intervention, but these are really the cases that most people focus on. And again, Somalia will be familiar to those of you who've seen the film Black Hawk Down. That was an intervention by the UN and the US to help the World Food Program distribute food to people who were starving in Somalia and to counter the warlords who were hijacking food supplies and also killing civilians. Of course, it ended badly, and the way it ended badly had enormous influence on Rwanda a year later in 1994. So with Rwanda, you had approximately 500,000 members of the minority Tutsi group who were slaughtered in the course of 3 months, really the fastest genocide on record, and a refusal, by and large, by the international community to intervene. There was an attempt to pull out existing peacekeepers. A rump peacekeeping force did stay behind to try to protect civilians, but it had very limited power and very limited ability to do that. Towards the very end of the genocide, you did have the UN authorize France to step in with Opération Turquoise, which was deeply problematic, partly because while it saved members of the Tutsi minority, it also helped protect the génocidaires and allowed them to flee to safety in Eastern Democratic Republic of Congo, where they have continued to destabilize the region. Bosnia from 1992 to 1995 saw the creation of safe havens in places like Srebrenica that were guarded by UN peacekeepers. In Srebrenica, it was a Dutch battalion, and it was when the safe enclave, the safe haven, was overrun by Serbian forces, the peacekeepers surrendered, and you had 7,000 to 8,000 Bosnian men and boys who were massacred, and that was later found to be a genocide. You then had various forms of intervention in Bosnia over the course of the war, and later on that morphed into Kosovo. Kosovo and Rwanda are thought to be really the big turning points. Rwanda was sort of the shame of the international community for not intervening to stop a genocide. Kosovo was, on the other hand, an effort by NATO without UN Security Council authorization to stop Milosevic's ethnic cleansing of Kosovar Albanians from Kosovo. And in a very famous report that was done after the Kosovo intervention, it was deemed that the intervention had been illegal because not authorized by the UN Security Council, but legitimate, that is, morally and politically legitimate. So again, pointing up there, the tension between legality and moral, ethical, and political legitimacy. Darfur, you have an ongoing civil war from 2003 and various attempts to intervene, mostly eventually with peacekeepers, joint UN, African Union peacekeepers. Iraq, the second Gulf War in 2003 was done, as most of you will know, on the basis of weapons of mass destruction. When the weapons of mass destruction were not found, a post hoc rationale that some provided for the invasion was that it was done for humanitarian reasons, that is, to protect the Iraqi civilians from the repression of Saddam Hussein's regime. Again, most people feel that Iraq was not a humanitarian intervention and that the attempts to justify in that way post hoc did enormous damage to the notion of humanitarian intervention. Libya is really kind of a remarkable case. It is the first and so far only time in which the UN Security Council has authorized humanitarian intervention in a timely way. However, that intervention very quickly led to regime change, and as a result, Russia and China and a number of the other BRICS states, as well as other states in the global south, feel that NATO used the UN Security Council resolution in Libya unfairly to overthrow Gaddafi rather than just to save civilians. And the debates about Libya are what have led to, in part, to blockage at the UN Security Council around Syria. So to date, we see no attempt at by the UN Security Council to authorize military intervention to stop the slaughter and the civil war in Syria. And it seems that that is partly because both China and Russia, in addition to being allied with the Syrian regime, also feel they got burned in Libya. Okay, so how does international law fit with humanitarian interventions? It's important to recognize that there are different bodies of international law out there. For this course, you've already looked at international humanitarian law and international human rights law, but there's another body of international law called use of force. And humanitarian intervention is governed by the international law on the use of force. Now, both international humanitarian law and international human rights law are relevant when we think about humanitarian intervention, partly in terms of looking at whether there is cause to intervene or not, but also once an intervention has commenced, international humanitarian law will govern the conduct of that intervention. Now, use of force, which is referred to by its Latin term jus ad bellum, the law on this is really pretty straightforward and pretty simple. The UN Charter generally prohibits the use of force, and that is set out very clearly in Article 2.4 of the UN Charter. There are only two exceptions to the prohibition on the use of force. The one exception is when the Security Council has approved the use of force under Article 42 of the UN Charter, or when a state is using force in self-defense, as per Article 51 of the UN Charter. Those are the only two exceptions. Now, some scholars, some human rights actors make a creative argument that Article 2.4 does allow for humanitarian interventions that are not approved by the UN Security Council and that cannot be considered self-defense. They make this creative argument by saying that, hey, look at Article 2.4, it emphasizes territorial integrity and political independence. A humanitarian intervention, in their argument, is not against the territorial integrity or political independence of any state. And in their view, it's consistent with the purposes of the United Nations, since one of the purposes of the United Nations in the UN Charter is human rights. But again, that is a creative interpretation. In my view, it's a bit of a stretch, but it's just worth knowing that that is out there. There are a number of key cases by the International Court of Justice, the World Court located in The Hague, that deal with the use of force. And I've put up the key cases here, the Corfu Channel case, the Nicaragua versus US case, and the Congo versus Uganda case. The most important of these cases is really the Nicaragua case. Nicaragua took the United States to the International Court of Justice in the 1980s over the US's interventions and use of force in Nicaragua in its attempts to defeat the leftist Marxist Sandinista government. What the US was doing was a range of different uses of force. It was supplying arms and training to the Contras, the right-wing rebels who were trying to overthrow the Sandinista regime. The U.S. was also dropping mines in the harbor of Managua. And the defense that the U.S. made was that its actions were justified by human rights, that Nicaragua's Sandinista regime was violating human rights, and that the U.S.'s attempt to overthrow that regime would be good for human rights. The International Court of Justice absolutely rejected that argument. The question is whether they were just arguing narrowly on the facts in that particular case, or whether we think about that having sort of wider precedent. And again, that gets into complicated issues around international law. But again, this is a very important case that makes the point that use of force cannot be justified simply on the basis that it's supposedly for human rights. And it also, again, points up that regime change is this particular regime change by military use of force is disfavored in international law. Humanitarian intervention is obviously highly political. There are a number of questions that come up. One of them is when to intervene. Another is who should intervene. Political scientist James Pattison has written an entire book looking at who should intervene, and considers that, well, those who should intervene are those with the capability to do so. There's also the question of how to intervene. And again, we would look at diplomatic and humanitarian and other aspects, not just military interventions. When we're talking about military interventions, though, and we're thinking about the international law on use of force, then we also have to think about how do you get agreement at the UN Security Council so that there's authorization. And finally, is there a reasonable chance of success? Will the humanitarian intervention, whether peaceful or military, actually make the situation better? And what do we mean by better? Well, typically what we're meaning is saving civilians. Okay, so let's talk about the shift from humanitarian intervention to the responsibility to protect. Over time, humanitarian intervention mostly came to connote military intervention. And that was seen as deeply problematic. So, for example, the classic humanitarians, folks like the International Committee on the Red Cross, felt very strongly against the notion of humanitarian interventions. And they took the perspective that, as you see here from this quote from their legal division, the term humanitarian should be reserved to describe action intended to alleviate the suffering of victims. And they thought the decision to use force, to do military interventions, was not humanitarian. So that was their main concern, that the humanitarian brand had been debased by the labeling of military interventions as humanitarian. Also, as you will know, the ICRC really doesn't take a position on the legality or the morality of going to war. They take a position on the legality and morality of conduct in war, during war. That is, in other words, they focus on jus in bello rather than jus ad bellum. The great paradox of military intervention for humanitarian or supposedly humanitarian reasons is that you're basically killing to improve the human rights and humanitarian situation. And there are those who would argue that killing in the name of human rights and humanitarianism is unjustified. And there's always the concern that the killing may actually end up worsening the human rights and humanitarian situation. Very quickly, just to, in this sort of very simple table here, is just to juxtapose humanitarianism with military intervention. So as you can see on the left-hand side, I've listed the basic 4 principles of humanitarianism: humanity, impartiality, neutrality, and independence. And again, the focus of humanitarianism is on jus in bello, that is, the conduct during war. Military intervention, on the other hand, is focused on the decision to go to war, jus ad bellum, which is different. And what we see is that military intervention often ends up privileging the interests of states, even if it's justified in the name of humanity. Military intervention is always going to be selective. There is never going to be, military intervention every time there is, serious threat to civilians. Um, Military intervention is obviously about taking sides, and usually taking sides against the state where the intervention is happening. And that is involved, if that state is involved in killing its own civilians, or if it's a consensual military intervention done with the consent of the state, then it'll be taking sides against the rebels or forces opposed to the state that are also killing civilians. Military interventions are obviously not going to be independent because you're going to have various players who are supplying the troops and the material for making war. Now, responsibility to protect was an attempt in some ways to rebrand humanitarian intervention. And it really comes out of the failures in Rwanda in 1994 to stop the genocide, and the failure in 1999 of NATO to get UN Security Council authorization for protecting civilians in Kosovo. The notion of responsibility to protect was partly came from former UN Secretary General Kofi Annan, who, remember, had been the head of the Department of Peacekeeping Operations during both the debacle in Rwanda and in Bosnia. And he felt very strongly that there needed to be a redefinition of sovereignty, and he felt very strongly that both Rwanda and Kosovo had weakened the UN, and particularly the UN Security Council. The upshot was that in 2001, Canada established a commission known by its acronym ICISS that was looking at this issue around state sovereignty, and Gareth Evans, who was one of the commissioners, came up with the term responsibility to protect. And it's really quite remarkable. So the term responsibility to protect was coined in 2001. In 2005, as we will see in just a minute, the notion was adopted by all member states of the UN, and today it is considered a new international norm. So a very rapid norm creation with responsibility to protect. And again, showing that ideas do matter, right? Gareth Evans' idea about responsibility to protect has had real impact in the world and has changed the discourse and, to a lesser extent, the actions in international relations. Okay, so what was responsibility to protect about? It was really sort of two key innovations. The first was to shift the focus from state to people. And again, that is linked to developments that were going on at the time in terms of a shift from security being focused on state security to the notion of human security. And again, this reflects the importance of human rights thinking, but it's very radical. It's extraordinarily radical. If you go back and you look at the UN Charter from 1945, it's clear that the UN Charter was mostly focused on states, and it was mostly focused on maintaining international peace and security. And what Kofi Annan did in his tenure as UN Secretary General was to shift the UN's focus from international peace and security to human rights and development, making those co-equal pillars of the work of the UN, and shifting the focus from states to people, or states to individuals within those states. The second key innovation of responsibility to protect was the redefining of state sovereignty. And so here the idea is that state sovereignty brings with it a responsibility, and that is a responsibility to protect the civilians within the borders of the state. And if the state fails to do that, then the state's sovereignty can be breached. And again, that is radical, okay? That's not something that is provided for at all in the UN Charter. In fact, Article 2.7 of the UN Charter makes clear that the international community shouldn't be interfering in the domestic affairs of states. And so historically, under international law, states were pretty much free to do what they liked to those people within their borders. And international law only dealt with the relationship between states. Human rights law, human rights discourse makes it a matter of international concern how states treat the people within their borders. Okay? And responsibility to protect is kind of encapsulating that notion. In 2000, so you have the ICISS in 2001 issues its report on responsibility to protect, and after that, the UN Secretary General Kofi Annan picks up and holds a number of consultations and high-level panels in the UN to talk about responsibility to protect. And the result of that is at the 2005 World Summit, in that outcome document, which is very lengthy, you have 3 paragraphs that address responsibility to protect. Now, the concept of responsibility to protect in this document is watered down from what had been proposed by the ICISS Commission in 2001, watered down from what the various high-level panels and Kofi Annan had wanted, but still, this is the most authoritative version of responsibility to protect that we have, because it's precisely the one that UN member states agreed to. There are 2 key paragraphs in the World Summit Outcome document. The first is paragraph 138, and 138 makes 2 things clear. First, that each individual state has the responsibility to protect its populations. That is, not just its citizens, but its populations, groups within, people within its borders, from 4 international crimes: genocide, war crimes, ethnic cleansing, and crimes against humanity. Ethnic cleansing actually isn't defined in international criminal law, and it can be a component of either genocide, war crimes, or crimes against humanity, just as by and by. The other thing that paragraph 138 makes clear is that the international community should help individual states exercise their own responsibility to protect. Paragraph 139 is the most important paragraph, okay? In this paragraph, it makes clear that there may be a need for the international community to take timely and decisive collective action, okay? And that would include military means, that is, use of force. And I've italicized some of the wording here that's important to understand. Through the Security Council, right, makes very clear that it's only the Security Council that can authorize military use of force for responsibility to protect purposes. In other words, what NATO did in Kosovo is not acceptable. Okay, and again, it flags up that the collective action has to be in accordance with the UN Charter. And again, what that means is that use of force is prohibited except where authorized by the UN Security Council. The World Summit Outcome document makes it clear that this collective action has to be done on a case-by-case basis. By contrast, the ICISS report from 2001 set out a bunch of criteria for making decisions around military use of force for responsibility to protect. The World Summit Outcome document scraps those criteria. Now, this may seem like a lot of wordsmithing or a lot of fuss about nothing, but what it's really doing is showing that the UN member states are very uncomfortable with setting out criteria because they are fearful that the criteria will lead to more military use of force for responsibility to protect. They want it to be very much case by case. That means that it is going to be highly political. As we see, this sort of collective action, timely and decisive collective action, has to happen where peaceful means are inadequate, but also, very importantly, where there are 4 crimes going on: genocide, war crimes, ethnic cleansing, and crimes against humanity, but also not just where those crimes are happening, but where the national authorities are manifestly failing to protect their populations from those crimes. Okay? Those national authorities, those states, it's not just about failing, it's manifestly failing. Now, the World Summit Outcome document doesn't really tell us what manifestly failing means. And subsequent interpretations of responsibility to protect by the UN Secretary General and his office don't really help us very much in that way either. There have been a number of scholars, including Adrian Gallagher, who have talked and tried to define what is meant by manifestly failing. Okay, so the UN Secretary General made clear that when you look at the World Summit Outcome document, there are 3 pillars under the responsibility to protect. The first pillar is the state's responsibility to protect its own population from these 4 crimes. The second pillar is the international community's assistance to states to help those states consensually protect their population from those 4 crimes. And pillar 2 is where most peacekeeping missions fall. Pillar 3 is the international community's timely and decisive response. And here again, it's important to remember that it includes not just military intervention, but diplomatic, humanitarian, and other peaceful means. What is the legal basis for the responsibility to protect as set out in 2005 by the World Summit Outcome document? Now, the UN Secretary General in a 2009 report said, quote, that the responsibility to protect is, quote, firmly anchored in well-established principles of international law, end of quote. And frankly, that was a bit of a stretch. It's a bit of wishful thinking. It's important to realize that there is no treaty for responsibility to protect, okay? And a treaty would bind the states that signed and ratified that treaty to enact responsibility to protect. There is no such treaty. Responsibility to protect is really a creative interpretation or reinterpretation and extension from existing treaties, treaties that include the UN Charter, the Genocide Convention, the Geneva Conventions, and the International Criminal Courts Treaty, which is often referred to as the Rome Statute. It's also important to recognize that the responsibility to protect is also not currently customary international law. There are really two forms of international law. One is treaty law. That's the one that is mostly used in this day and age. But there is also customary international law. Customary international law has two components to it. One is general state practice, and the second is this weird thing that goes by the Latin phrase opinio juris. And what opinio juris is that the general state practice has to be because states think that there's a law-like obligation. So R2P is not customary international law because it is not yet general state practice, and because states that do responsibility to protect are not doing it at this point out of a sense of law-like obligation. Okay, customary international law, it's super confusing. International lawyers spend a whole lot of time arguing with one another over it. The reason it's still important, even though the focus today is on treaties, is because customary international law can potentially bind, to the extent that it exists on particular topics, it can bind states that have not signed those treaties. Okay, so for example, prohibition on torture is part of customary international law. That means even states that have not signed the Convention Against Torture are bound under customary international law not to torture. Finally, there's something out there called soft law, which you've come across before. Soft law is not real law. Soft law is what international human rights lawyers hope will one day become law. And soft law can develop over time into treaties. It can also develop over time into customary international law. Typically, when we're talking about soft law, we're talking about UN General Assembly declarations or UN Security Council resolutions, or even UN principles and UN guidelines. At this point in time, responsibility to protect is very much soft law. It's an international norm that gets reflected in things like the 2005 World Summit outcome and in subsequent General Assembly declarations and UN Security Council resolutions. But it is not binding international law because there's no treaty and because it's not customary international law. Okay. The UN Secretary General has done a number of reports around the responsibility to protect. This is the new UN Secretary General Ban Ki-moon, who has really picked up where Kofi Annan left off and has been a real booster for responsibility to protect, and has commissioned and produced a number of reports on responsibility to protect. In his earliest report in 2009, he tried to emphasize that responsibility to protect is not an adversary of state sovereignty, it's an ally of state sovereignty. And again, there is a lot of controversy around this. States are much more willing to accept Pillars 1 and Pillars 2 of responsibility to protect, but most states still see Pillar 3 of responsibility to protect as adversarial to state sovereignty. Why? Because it allows the international community to use non-consensual means, including military use of force against a state that is not protecting its populations from those 4 international crimes. The UN Secretary General's 2009 report also says something very important, which is let's take what we have with the World Summit outcome and find ways to implement it. There's a recognition here that the World Summit outcome document didn't give advocates of responsibility to protect everything they wanted, but cautioning against attempts to reinterpret or renegotiate what was agreed in 2005, partly because a number of states, particularly the BRICS countries, Brazil, India, China, Russia, South Africa, have over the years since 2005 become much more wary about what was agreed to in 2005 on the responsibility to protect. And again, there are other states in the global south that have exhibited some buyer's remorse over what they agreed to in 2005 on responsibility to protect in the World Summit outcome document. Okay, just wanted to flag here that there are these subsequent UN Secretary General reports that are out there. And again, these are easy enough to find on the web and will give you a sense of the UN's current thinking around responsibility to protect. The 2013 UN Secretary General report did make very clear that military enforcement under responsibility to protect under Pillar 3 really should be a last resort, and that while it's part of the toolbox, there's lots of other tools that are available under the UN Charter to protect populations, and those other tools do not involve military enforcement. There are a number of critiques out there of responsibility to protect, and I've listed the key critiques here and some of the scholars who make those critiques. The first critique is that responsibility to protect has actually made very little difference in the real world. So people like Aidan Hay here have argued that you don't see states using the language of responsibility to protect very much, and also not acting congruent to the responsibility to protect. And he points to, for example, in Libya, you had Obama, Cameron, and Sarkozy who, in the context of Libya in 2011 and the efforts to stop the civil war and to oust Gaddafi, those 3 leaders gave a number of speeches. They wrote an editorial for the New York Times, and what's surprising is that they don't invoke the responsibility to protect. And so Aidan Hay here argues, well, hey, that shows that it doesn't count for very much. It's deployed rhetorically in a very haphazard fashion, doesn't mean very much. Others have countered that and argued that, hey, they don't have to use the magic formula with the words responsibility to protect. They can use other words that are still evocative of responsibility to protect. So again, debate there. Second critique of responsibility to protect is that it ignores politics, and that at the end of the day, what really counts is not the international norm of responsibility to protect, but politics at the UN Security Council and local politics at the state level. A third critique, and this is one that is made by people like David Chandler, but also certainly people like Noam Chomsky, is that responsibility to protect, like humanitarian intervention before it, is just a disguise for neo-imperialism. And again, these critics point to where humanitarian intervention or responsibility to protect has led to regime change, places like Kosovo and places like Libya. A fourth critique is that responsibility to protect is politically and morally inconsistent. And the argument here is that it is highly selective. This can feed back into the previous argument about the selectivity being linked to where certain powerful states want to throw their weight around for neo-imperialist reasons. But the concern, there's also a moral concern here, which is, how do we think about responsibility to protect as an ethical norm if it's only applied in a very highly selective form? The response, and again, what is often pointed to is, how do we justify having done responsibility to protect in Libya but not in Syria, or in Libya but not in Bahrain or in Yemen? And one of the answers to the charge of inconsistency is that at the end of the day, these are different cases, right? Libya is not Syria, Syria is not Libya. And so inevitably, there is going to be inconsistency because these are not similar cases. There's also an argument that gets made that, hey, inconsistency and selectivity is inevitable as a result of UN Security Council politics. We're not going to change that until there is reform of the UN and the UN Security Council, which is unlikely to happen anytime soon. And does the choice become one of doing good inconsistently or doing nothing across the board? And what kind of moral choice is that? So again, big debate there. The final critique, and a very controversial critique of responsibility to protect that has been made by Alan Cooperman and a few others, is that it actually can cause more mass killing. And the argument here that Cooperman makes is one around the idea of moral hazard. And he makes this argument in the context of both Kosovo and Darfur, that in essence, rebel groups will incite a state to commit genocide or crimes against humanity or war crimes or ethnic cleansing as a way to draw in the international community to bring them in on their side. And so again, real concern about that. Others have argued that the evidence for moral hazard, Alex Bellamy in particular, that there really isn't that evidence. And again, part of the rejoinder to Cooperman is that humanitarian intervention, responsibility to protect, has been highly inconsistent, highly selective. And so it's very hard for rebel groups to be able to count on the international community to intervene militarily on their side. Alex Bellamy is one of the most famous scholars and advocates of responsibility to protect. He has published now 3 books and multiple articles around responsibility to protect. His latest book is very clearly a defense of responsibility to protect, and he defends it from the various critiques that were listed on the previous slide. And again, Alex Bellamy is very kind of pragmatic in his approach to responsibility to protect. His argument is that it is now an established norm. That's something that others would contest, but that it's an established norm, an established principle, but it is still being slowly translated into practice. And he is very, he likes to remind us that this principle is still very new, and its implementation is, there hasn't been a whole lot of implementation, and these are still very early days. That said, he argues that responsibility to protect has made significant contributions. It has reminded political leaders of their responsibility to protect their populations, thereby making it harder to justify killing or doing nothing. He also argues that responsibility to protect has guided policy and decisions, particularly in the UN Security Council. And he points in particular to improved preventive diplomacy of the type that was done by Kofi Annan after he was UN Secretary General in places like Kenya after the 2007-2008 post-election violence. Finally, Bellamy talks about how R2P has given increased impetus for protecting civilians and preventing armed conflict. So again, makes very clear that responsibility to protect is not the best thing since sliced bread, but yet has had important contributions, and that these contributions are slowly developing. One thing to point out here is, which is important, is that there is a real distinction between protection of civilians and responsibility to protect. The language of protection of civilians and responsibility to protect sometimes gets muddied and muddled and confused and conflated in UN Security Council resolutions, but it's important to keep these things separate. And part of the reason to keep these things separate is, as listed here, they apply in different situations. So protection of civilians only applies to armed conflict, whereas responsibility to protect can apply in peaceful situations as well as situations of armed conflict. Protection of civilians applies very broadly, whereas responsibility to protect only applies where you have 4 crimes: genocide, crimes against humanity, war crimes, and ethnic cleansing going on. And finally, protection of civilians applies just to civilians, whereas responsibility to protect applies to all people, populations. Okay, so they are two different concepts, even though they do get often muddied. What is clear is that there is a lot more acceptance within the United Nations and by UN member states of protection of civilians. The reason is that R2P comes with the baggage of humanitarian intervention, and particularly the baggage of military interventions for humanitarian reasons, which in the past, in certain places, have led to regime change. So again, a number of UN personnel, as well as a number of member states, are much happier using language and discourse around protection of civilians than they are around the language of responsibility to protect. Okay, let me turn now to, and this is much shorter, let me turn now to the second topic that I want to cover today, which is the responsibility to prosecute. And here what we're talking about is the responsibility to prosecute not just human rights violations, but international crimes. As you know from your module guide, there is something out there called the Justice Cascade. And so Catherine Sickink, who's an international relations scholar, has talked about how there is a new norm that calls for the prosecution of international crimes. And this new norm is what she terms a justice cascade. There's stronger evidence of this justice cascade going on in certain parts of the world than in other parts of the world. The justice cascade is really most apparent in, for example, Latin America. But there are other scholars like Lee Payne who have countered or qualified the notion of the justice cascade. The responsibility to prosecute international crimes can also be seen in a number of other ways. First, the UN, since the Lomé Peace Accord of 1999, has refused to support amnesties for international crimes. In the past, it was very common for peace agreements to include amnesties for state actors and non-state actors who had committed international crimes. The UN, since Lomé, has refused to sign off on those amnesties. And so amnesties are now disfavored, increasingly disfavored, as a matter of international law, but also as a matter of practice in peace negotiations. There's also been the rise of international criminal law and the rise of international criminal tribunals. Both the ad hoc international criminal tribunals for Yugoslavia and Rwanda, the permanent criminal tribunal of the International Criminal Court, but also mixed international national criminal tribunals in places like Sierra Leone, Timor-Leste, and Cambodia. There's also been the rise of universal jurisdiction, and the idea behind universal jurisdiction is that states can try international crimes in their domestic courts, international crimes that have happened in other states in their own domestic courts. And again, universal jurisdiction is quite controversial. There are only some states that have had statutes giving their domestic courts universal jurisdiction over international crimes committed elsewhere, particularly Belgium and Spain. But again, this has been part of this larger justice cascade, or this increased responsibility to prosecute international crimes. International criminal law is, again, a separate area of international law. It's separate from use of force. It's separate from international human rights law. It's separate from international humanitarian law, but they have links, okay? So the worst violations of human rights law are genocide, crimes against humanity. These are also crimes under international criminal law. The worst violations of international humanitarian law are grave breaches of the Geneva Conventions, also known as war crimes, and war crimes are, again, prohibited and can be prosecuted under international criminal law. And finally, there's also an international crime of aggression, which is obviously linked to the law prohibiting the use of force except where authorized by self-defense or the UN Security Council authorization. It's taken an incredibly long time to get a permanent international criminal court. A permanent international criminal court was first proposed in 1948 in the Genocide Convention. It was a genocide convention to prevent and to punish genocide. And part of the way that was thought of to punish it was to have an international criminal court. It took 50 years to realize the idea of an international criminal court. In 1998, you had the Rome Treaty that was agreed to. Rome Treaty was drafted. It helped create the International Criminal Court, but that court only came into effect in 2002 when you had enough states who had signed on to ratify that treaty. Currently, you have 123 state parties out of something like 195, 196 total states in the world. Very importantly, 3 of the permanent 5 members of the UN Security Council, China, Russia, and the US, have not ratified and are not members of the International Criminal Court and are not likely to become members of the International Criminal Court, which means that the International Criminal Court remains fairly weak. How do situations come to the ICC? Very importantly, situations are country situations. They're not individual cases. And again, there's that language that gets used in relation to the International Criminal Court. Country situations come to the ICC in 3 ways. They can be referred by other states. What has been an interesting development and what was not anticipated is that a number of states have referred themselves to the ICC. So Central African Republic, Cote d'Ivoire, Uganda, and the Democratic Republic of Congo, they have all, the leaders of those states have all referred their state to the International Criminal Court. Again, something that was unexpected. A situation can also come to the ICC via the UN Security Council. This is the only way that a situation can come to the ICC where a state has not ratified the ICC treaty, the Rome Statute. And so we see, for example, with Sudan over Darfur and with Libya, states that had not ratified the ICC treaty, those situations came to the ICC because the UN Security Council had referred them. And finally, the prosecutor can use his or her own powers to bring a situation to the ICC. This is more rarely done, and the most clearest example of this was over Kenya after the 2007-2008 post-election violence. So how does the prosecutor and the court decide which of these country situations to investigate? It looks at a number of things. It looks at the jurisdiction. Okay, so does it have jurisdiction, a temporal jurisdiction, that is jurisdiction in terms of time? Again, remember that temporal jurisdiction of the court only goes back as far as July of 2002 when the court came into being. It also only has temporal jurisdiction going back to when a state ratified the treaty. Okay, so it has to be after July of 2002. But if a state ratified the treaty after July of 2002, that also provides a cutoff. Subject matter jurisdiction. Remember that the court and the prosecutor only have jurisdiction over genocide, crimes against humanity, and war crimes. At some point in the future, the court may have jurisdiction over the international crime of genocide, but that is not currently the case. The prosecutor and court also have to have personal and territorial jurisdiction, and again, those are complicated areas of international law and international criminal law that we won't go into here. The prosecutor and court also have to look at whether the situation is admissible. And the key thing here is complementarity. This is the fundamental principle of the ICC. What complementarity means is that the court is a court of last resort. The court is complementary to state sovereignty and to state jurisdictions. In other words, the court only, a situation is only admissible if a state has shown that it is unwilling or unable to prosecute. Okay? If a state is willing or able to prosecute, then the situation is not admissible. And again, what this is, it's about respecting state sovereignty, and it's the only way that states were willing to agree to and ratify the ICC treaty. Another component of admissibility is gravity. And so, again, not all situations of genocide, crimes against humanity, and war crimes are equally grave. The prosecutor and court have limited resources. They're going to focus on those situations with the most gravity. Finally, the prosecutor and court can look at what is termed in the ICC treaty the interests of justice. It may decide not to go ahead with investigating a situation in the if it seems to be against the interests of justice. What all this shows is that there is an enormous amount of discretion built into the ICC and the ICC treaty, discretion allowing the prosecutor and court to either investigate or not investigate situations. Currently, there are 9 country situations: Uganda, DRC, Democratic Republic of Congo, Central African Republic, Mali, Sudan, Libya, Kenya, Cote d'Ivoire. And I've highlighted here the ones that also have an element of responsibility to protect or humanitarian intervention. There are also 21 cases currently before the court. Cases involve individuals. Some of those cases involve groups of individuals. What is interesting about the International Criminal Court is that it has been pursuing heads of state: al-Bashir in Sudan, Kenyatta in Kenya, though that case was recently dismissed, but the ongoing case against the Kenyan Vice President Ruto. The ICC is also pursuing former heads of state like Laurent Gbagbo, of the former president of Cote d'Ivoire. Now, there are links between the responsibility to protect and the ICC. Links between responsibility to protect and responsibility to prosecute. First, both the R2P and ICC focus on the same atrocity crimes, that is, genocide, crimes against humanity, and war crimes. Secondly, under both responsibility to protect and the ICC, states have the primary responsibility to protect their populations or to prosecute individuals for these atrocity crimes. In other words, the international community comes in as a last resort, both for responsibility to protect and for the International Criminal Court. Third, the doctrines of responsibility to protect and the ICC are rooted in a liberal cosmopolitanism. And fourth, both responsibility to protect and the ICC are prone to politics, particularly at the UN Security Council. The advocates of responsibility to protect, as well as advocates of the ICC, have recognized this linkage. And so, for example, you've had the UN Secretary General as well as the ICC prosecutor who've recognized that the International Criminal Court is part of the toolbox of responsibility to protect. Others have stated that this should be treated with a whole lot more caution. It shouldn't be celebrated. It should be a cautionary. ICC referral has been used as a responsibility to protect response. It can be seen as a pacific, peaceful, non-military response under Pillar 3 of responsibility to protect. It can also be seen as evidence of other measures before taking the last resort of military intervention. The UN Secretary General's report in 2012 makes the case that the threat of referrals to the ICC can undoubtedly serve a preventive purpose, and the engagement of the ICC can contribute to the overall response. Again, that is a statement by the UN Secretary General. It's not clear that that is backed up by evidence. Okay, so has the threat of referrals to the ICC, say in the context of Libya, did it have a preventive purpose? It's not clear that it did. As you know from the module guide, ICC and the use of the ICC for responsibility to protect purposes can have unintended consequences. And that was clearest in the case of Sudan and Darfur. In the wake of the arrest warrant for President al-Bashir, took action. He expelled 13 humanitarian NGOs and shut down 3 local human rights NGOs because he felt that they had been passing information to the International Criminal Court, and the upshot of passing that information had obviously been the arrest warrant against himself. And so he wanted to show humanitarian NGOs and human rights NGOs who was boss. So the unintended consequence of the ICC's arrest warrant was that it made the humanitarian situation in Darfur a whole lot worse and made it much more difficult to document, to witness human rights violations or violations of international criminal law in Darfur. A couple of years ago, our center hosted a Sudanese human rights activist who had been working in Darfur with his NGO. His NGO was one of the ones that were closed, shut down by the Sudanese government after the arrest warrant against al-Bashir became public. And he did a lot of soul searching while he was here and talked about, whether, they should have been doing as much documentation of these crimes committed in Darfur as they did. Would they have done as much as they did knowing their organization would be shut down, knowing that they wouldn't be able to continue their human rights work? Again, very difficult choices for human rights actors, and particularly difficult choices for humanitarian actors, particularly those humanitarian actors like MSF that don't agree with the ICRC and believe in witnessing and calling out violations of human rights law, humanitarian law, and international criminal law. The South African president at the time, also criticized the ICC's arrest warrant for, in a sense, uniting the African Union behind al-Bashir. And again, circumventing, in a sense, regional politics in the African Union. So again, what this points up is that responsibility to protect and the responsibility to prosecute have real ramifications for humanitarian actors in the field. And I'm looking forward to discussing more of this with you in our Q&A in a couple of weeks. Thanks very much.